Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
No delaying for what you saying, yo. Silly with my 9 milli with the dilly, yo. When I be on my yes, I do my duty, yo. While up in the club, I be while in the studio. You don't wanna vibe, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. I'm a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga, shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in a place to be. If you really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in a place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in a place to be. If you really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in a place to be. If you really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in a place to be. If you really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in a place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Hello, and welcome back to my channel, guys. It's your girl, Diva Divine Light. Hope everybody's having a great day. Well, hello to everyone in the chat. As you can see, this is a pre-recorded live. It's going to be a short one. I don't know how long exactly, but we're going to be talking about, we're going to listen. I want you guys to listen to Jim DeRogatis, a part of his book, Soulless. And in this particular chapter, chapter 4, he talks about Tiffany, Aaliyah, Javante, the girls, the lawsuit, the parents of Aaliyah, the teacher. A lot of things are in that chapter. But one part in that chapter, he talks about the lawsuit that R. Kelly, not a lawsuit, insurance company, Hartford Insurance Company, which was the homeowner's insurance company for his homes, for R. Kelly's homes. And he wound up trying to get money out of the insurance company so that he can pay off Tiffany Hawkins' lawsuit, so he could settle the lawsuit with her. They denied it, and he appealed it. And when he had appealed it, they made a decision on the appeal. And of course, they denied it. So what I have here is the actual appeal paperwork, the appellate paperwork that went through for the Hartford Insurance Company. What we're going to do is we're going to listen to Jim talk about it in his book, and then we're going to listen to the actual appeal decision. And this happened December of 1999. Now, for those who are watching the replay, please drop your comments in the comments section below. I like to see comments. I want to hear people's comments. Please have respectful comments, and they will not get deleted. If you come out disrespectful, I won't get a chance to see your comment. My mods will delete them. So if you want to have an open conversation and I can reply to you, be respectful. Okay? And for those in the live, what's up, guys? For those just joining in, hello, hello, hello. I'm not going to shout everybody out individually because this is a pre-recorded live. Shout out to the whole OCOV family, and shout out to my YouTube family, and shout out to all the people in the bushes watching, learning, and to my loves that are in the back, of course, watching. Hello, everyone. So we are going to go into that. Okay, so let's start off with Jim. I gotta try to adjust my mic to the hold on, give me a second, guys. I gotta remember the last time I had the microphone too close and it sounded muffled. Okay, so now I'm going to go on mute. Oh no, I can't go on mute because I don't want to share this. So, all right. Here we go.
Regretted taking R. Kelly's advice. That was the biggest hurt to me, and to this day, I feel that I could be something else if I stayed in school. Sometimes Kelly gave the girls gifts. He treated us very well, the Kenwood classmate said. We got anything we asked for, but we weren't going to ask for much. A pair of Air Jordans or $100 was a lot of money to us. She said she stopped having sexual contact with Kelly because I have this jealous thing when I'm sleeping with somebody. If they sleep with somebody else, I kind of get upset. She thought Tiffany's relationship ended for similar reasons. Tiffany was jealous of other girls, period. Even though Tiffany claimed to be close to her, she was kind of jealous of Aaliyah, whom the two met when Aaliyah was 12. Later, I guess Tiffany was trying to be around to cock block or whatever you want to call it, because I know Robert was sleeping with Aaliyah, and then Tiffany and Aaliyah fell out. Sources provided more detail about Tiffany's settlement. The former associate said it came the day after Tiffany gave a 7.5-hour deposition to Kelly's attorneys, Gerald Margolis and John M. Toohey. The case file did not include a transcript of the deposition. Although it was public record, the deposition had disappeared, and I never have found it. My source said it had been hair-raising stuff about a predatory relationship based on perverted sexual acts, including threesomes with underage girls. Demetrius Smith, Kelly's longtime road manager and personal assistant, confirmed. That deposition told the story of their relationship and mentioned other minors, with hours of graphic detail. The sworn testimony stunned everyone in the room. In exchange for $250,000, 1/40th of the $10 million she'd been seeking, Tiffany signed a non-disclosure agreement the next day, barring her from talking about any relationship or settlement with Kelly. Years later, I learned the Star actually tried to compel the Hartford Insurance Company to pay the settlement. In December 1999, Hartford sued him for pressing that claim, seeking a declaration that it owed no duty to defend or indemnify the insured under a homeowner's policy in an underlying lawsuit asserting claims of negligence and intentional sexual battery. Kelly appealed, and Hartford responded to the appellate court that the underlying complaint against the insured sufficiently set forth factual allegations of sexual misconduct with a minor to exclude coverage under an expected or intended exclusion. Hartford won the appeal, and Kelly paid Tiffany himself. A homeowner trying to have his insurer pay for illegal sexual contact with a minor has to stand as one of the strangest cases in the annals of the insurance industry, a business that has seen plenty of strange claims. The Kenwood classmate believed Tiffany settled with Kelly for so little because she just got tired of the case, which dragged on for 2 years. She kept 2/3 of the money after legal fees, and she promptly squandered all of it, my sources said. Tiffany just jumped once they started talking that money, Smith added. Abden compared it to Kramer leaping at the offer of free coffee for life in the Seinfeld episode about Java World, but I always wondered if there was more to the story. Jovanta Cunningham also appeared on Tiffany's witness list, and she initially talked to me off the record, and only reluctantly. She, the Kenwood classmate, and Tiffany had been Aaliyah's posse of 3 teenage girlfriends, whom everyone called Second Chapter. Jovante met Kelly at age 14 and later worked for him as a dancer and backing vocalist. She knew a lot, she told me, but if I would tell it, it would be in front of somebody's huge television camera, and they'd have to be paying me a whole bunch of money. Every time I told her the Sun-Times did not pay sources, she kept talking anyway. I got a quizzical look when one of the features editors overheard us on the phone. I had to speak especially loudly because my reluctant interview subject seemed to be shopping. "I like those shoes. I'll take those," she said at one point. "I've seen him do things I can't say," Jovante said of Kelly. "I'm not at liberty to say who, what, where." She did tell me she met Tiffany at a mutual friend's house. The first thing she said to me was, "I know R. Kelly." At the time, he was nobody. His first album hadn't even hit yet. She said, "Let's go over to his house." So we went over there. I don't know if she was a recruiter for him or what. She added that she believed Kelly made a mistake by settling with Tiffany. I thought it would only encourage more girls to come forward. And she said Kelly should have taken the lawsuit as a wake-up call. He should have learned from that and got some help. He definitely has something going on psychologically, and he needs to know there is repercussions. He has no value or respect for people as a whole. The brother got problems. The brother is ill. Robert's thing was a fresh body. I don't think it had anything to do with age. I think he goes for a fresh look, a fresh body, and it turns out to be a young body. There are a lot of different ways you could categorize it, but I'm not a psychologist. I'm just a person who witnessed some things, who had her own opinion of it. Jovante finally got to talk to somebody's huge television camera when she appeared 19 years later in the Lifetime docuseries Surviving R. Kelly. In it, she tearfully said she witnessed R. Kelly having sexual contact with 16-year-old Tiffany in the studio, as well as with 15-year-old Aaliyah on a different occasion aboard his tour bus. Abden and I knew we couldn't tell Tiffany's story without one more interview. We had to talk to Lena McClin about Kelly's visits to Kenwood Academy. So
Now, that was just the part of chapter 4 in Jim DeRogatis' book, Soulless. Now, you see how he was explaining about how R. Kelly tried to take money from his homeowner's insurance. They denied the claim, And this is the paperwork for the appeal and the decision. I'm going to let the read aloud read it. Okay?
Hartford Insurance Company of Illinois v. Kelly. Reset AA font size, print. Appellate Court of Illinois, 1st District, 2nd Division. The Hartford Insurance Company of Illinois, Plaintiff Appellant, v. Robert Kelly, Defendant Appellee, Tiffany Hawkins, Defendant. Number 1-983044. Decided, December 14, 1999. Hinshaw and Culbertson, Chicago, Kevin R. Cito, Nancy G. Lisher and Colleen Danaher Contreras of Counsel for Appellant. John M. Toohey, Alan J. Martin, Scott V. Scarpelli, Mayer, Brown and Platt, Chicago for Appellees. Plaintiff, the Hartford Insurance Company of Illinois. The insurance company brought an action against its policyholder, Robert Kelly, seeking a declaration that it owed no duty to defend or indemnify its insured under a homeowner's policy for an underlying lawsuit brought by Tiffany Hawkins in the Circuit Court of Cook County. On cross motions for judgment on the pleadings, the Circuit Court entered judgment for Kelly and against the insurance company, reasoning that the insurance company owed Kelly a duty to defend because there were sufficient facts pled in the underlying complaint to give rise to coverage. The insurance company appeals, contending that, 1, since Kelly's insurance policy excluded coverage for bodily injuries that are expected or intended, the underlying complaint against him for sexual misconduct against a minor absolves the company's duty to defend under the policy, and 2, the lower court erred in granting Kelly's cross motion for judgment on the pleadings, as it never ruled on the other policy provisions establishing no coverage. For the reasons articulated below, we reverse. Background. The insurance company issued a new homeowner's policy to Kelly for the time period of March 16, 1994, to March 16, 1995, at an annual premium of $976. The policy protected Kelly for personal liability losses and provided, if a claim is made or a suit brought against Kelly for damages because of bodily injury or property damage caused by liability, an occurrence to which this coverage applies, the insurance company will, provide a defense at our expense by counsel of our choice, even if the suit is groundless, false or fraudulent. Occurrence is defined therein as an accident, including continuous or repeated exposure to substantially the same general harmful conditions, which results, during the policy period in A. bodily injury or B. property damage. The policy further provided, however, that it did not apply to bodily injury or property damage that was expected or intended by the insured. On February 18, 1997, Hawkins filed a 24-count first amended complaint at law against Kelly and 7 separate corporate entities. As to Kelly, an entertainer and recording artist known as R. Kelly, the complaint contained a series of allegations under separate counts of negligence, intentional sexual battery and sexual harassment. In both the negligence and intentional sexual battery counts of the underlying complaint, it was alleged 2. Commencing on or about the year of 1991, the defendant, Robert Kelly, engaged in improper sexual conduct including intercourse with the plaintiff, Tiffany Hawkins, in that the plaintiff, Tiffany Hawkins, was a minor. 3. Beginning in 1991 up to and including October of 1994, defendant, Robert Kelly, was negligent in one or more of the following ways. A. Engaged in inappropriate sexual contact with the plaintiff, Tiffany Hawkins, including, but not limited to, engaging in group sexual intercourse with the plaintiff, Tiffany Hawkins, and other minors. B. Encouraged and engaged in inappropriate, intimate sexual contact with a minor. C. Was in violation of criminal statutes of the state of Illinois in engaging in sexual intercourse with a minor. D. Encouraged and engaged in conduct which defendant, Robert Kelly, knew or should have known was likely to cause severe emotional harm to plaintiff, Tiffany Hawkins. The sexual harassment count alleged similar facts, but was later dismissed by the circuit court. Upon receipt, Kelly tendered the complaint to the insurance company for defense under his homeowner's policy. The insurance company denied Kelly's request for a defense and instead filed an amended complaint for declaratory judgment in the Circuit Court of Cook County on May 19, 1997. And 6. The allegations of the underlying complaint may constitute a loss in progress or a known loss. And 6. The allegations of the underlying complaint may constitute a loss in progress or a known loss. On December 8, 1997, Kelly answered and counterclaimed, alleging that the insurance company breached its obligation to defend and that the underlying complaint, at a minimum, gave rise to potential coverage under applicable Illinois law and the terms of the policy. In response, on February 23, 1998, the insurance company filed a motion for judgment on the pleadings, contending that, because allegations of direct sexual misconduct by Kelly were contained in the underlying complaint, they gave rise, as a matter of law, to inferred specific intent to harm, and thus coverage was precluded under Kelly's homeowner's policy. On March 23, 1998, Kelly filed a company had a duty to defend because the allegations of the underlying complaint gave rise to covered or potentially covered claims under the policy. On June 4, 1998, after hearing argument, the circuit court denied the insurance company's motion and granted Kelly's cross motion for judgment on the pleadings. Specifically citing to the 5th District Appellate Court's ruling in Shell Oil Company v. ACNS, Inc., 271 ILAP.3D 898, 208 IL December 586, 649 N.E.2D 946, 1995, the lower court found sufficient facts in the underlying complaint to warrant coverage. On July 15, 1998, the insurance company filed a motion to reconsider, seeking reconsideration of the lower court's order in light of Illinois case law previously tendered to the court and relied upon by the insurance company regarding the inferred intent doctrine. In the alternative, the insurance company requested a clarification that its motion for judgment on the pleadings was denied only as to counts I and 4. On July 22, 1998, the circuit court entered an order stating that the intended purpose of a motion to reconsider is to bring to the court's attention changes in the law or errors in the court's previous application of existing law, citing Kaiser v. MEPC American Properties Incorporated, 164 ILAP.3D 978, 115 IL December 899, 518 N.E.2D 424, 1987. The court found that it did not misapply existing case law and, as such, it denied the insurance company's motion for reconsideration. On August 18, 1998, the insurance company timely filed its notice of appeal. Discussion. This is an action for declaratory relief, see 735 ILCS 5/2-701, West 1996, in which the circuit court granted defendants cross motion for judgment on the pleadings, see 735 ILCS 5/2-615E, West 1996. A motion for judgment on the pleadings is like a motion for summary judgment limited to the pleadings. Employers Insurance of Wausau v. Elko Liquidating Trust, 186 IL 2D 127, 138, 237 IL December 82, 708 N.E.2D 1122, 1129, 1999. Thus, judgment on the pleadings is proper, if the admissions in the pleadings disclose that there is no genuine issue of material fact, and that the movement is entitled to judgment as a matter of law. Employers Insurance, 186 IL 2D at 138, 237 IL December 82, 708 N.E.2D at 1129, quoting 3R, Michael, Illinois Practice Section 27.2, at 494, 1989. As our review of the case at bar hinges on the construction of an insurance policy, it is de novo. American States Insurance Company v. Columns, 177 IL 2D 473, 479-80, 227 IL December 149, 687 NE. 2D 72, 75, 1997, Outboard Marine Corporation v. Liberty Mutual Insurance Company, 154 IL 2D 90, 108, 180 IL December. 691, 607 N.E.2D 1204, 1212, 1992. Generally, in Illinois, an insurance company's obligation to provide or pay for counsel for its insured depends upon the allegations of the complaint and the applicable provisions of the insurance policy. West American Insurance Company v. Vago, 197 IL.3D 131, 136, 143 IL December. 195, 553 N.E.2D 1181, 1184, 1990. In cases where the underlying claim involves conduct that resulted in injuries that are either expected or intended by the insured, the insurance company is absolved from liability. See Scudder v. Hanover Insurance Company, 201 IL.3D 921, 927, 147 IL December. 386, 559 N.E.2D 559, 562, 1990. Because it is believed that the insured acted with specific intent to injure or cause harm to a third party. Cowan v. Insurance Company of North America, 22 IL.3D 883, 892 to 93, 318 N.E.2D 315, 325, 1974. A person who sexually abuses a minor cannot expect his insurer to cover his misconduct and cannot escape personal liability by claiming that he did not intend to cause any harm. In situations such as this, injury always ensues, and we conclude that one who manipulates children for his own sexual gratification intends any resulting injuries, as a matter of law. Emphasis in original. Western States Insurance Company v. Bobo, 268 IL.3D 513, 520, 205 IL December. 930, 644 N.E.2D 486, 491, 1994, quoting Foremost Insurance Company v. Wheatman, 726 F.Sup. 618, 622, W.D. Pa 1989. Accordingly, where an underlying complaint sets forth factual allegations of sexual misconduct, specific intent to harm is inferred as a matter of law, especially when the victims are minors. State Farm Fire and Casualty Company v. Waters, 268 IL.3D 501, 507, 205 IL December. 936, 644 N.E.2D 492, 496 to 97, 1994, Scudder, 201 IL.3. Relying on inferred intent case law, the .E.2D at 563, Bobo, 268 IL.3D at 516 to 17, 205 IL December. 930, 644 N.E.2D at 491. And he practical effect of the inferred intent rule is that the insurer will have no duty to defend or provide coverage to the insured. Bobo, 268 IL.3D at 516, 205 IL December. 930, 644 N.E.2D at 488 to 89. Relying on inferred intent case law, the insurance company in the case sub judice contends that, since Kelly's insurance policy excluded coverage for bodily injuries that were expected or intended, the underlying civil suit against Kelly for sexual misconduct against a minor absolves the company's duty to defend under the policy. Kelly, however, contends that the insurance company has a duty to defend, as the allegations of the underlying complaint must be construed liberally in favor of policy coverage with all doubts and ambiguities resolved in the policyholder's favor. United States Fidelity and Guarantee Company v. Wilkin Insulation Company, 144 IL.2D 64, 74, 161 IL December. 280, 578 N.E.2D 926, 930, 1991. In determining whether there is a duty to defend, a court looks to the allegations in the underlying complaint and compares those allegations to the relevant provisions of the insurance policy. Columns 177 IL.2D at 479, 227 IL December. 149, 687 N.E.2D at 75. If the facts alleged in the underlying complaint fall within, or potentially within, the language of the policy, the insurer's duty to defend arises. Columns 177 L2D at 479, 227 Il December. 149, 687 N.E.2D at 75. Moreover, the duty to defend extends to cases where the complaint alleges several causes of action or theories of recovery against an insured, even if only one or some of them are within the policy coverage. Maryland Casualty Company v. Peppers, 64 L2D 187, 194, 355 N.E.2D 24, 28, 1976. Here, both the negligence and intentional sexual battery counts of the underlying complaint include the following allegations. 2. Commencing on or about the year of 1991, the defendant, Robert Kelly, engaged in improper sexual conduct including intercourse with the plaintiff, Tiffany Hawkins, in that the plaintiff, Tiffany Hawkins, was a minor. 3. Beginning in 1991 up to and including October of 1994, defendant, Robert Kelly, was negligent in one or more of the following ways. A. Engaged in inappropriate sexual contact with the plaintiff, Tiffany Hawkins, including, but not limited to, engaging in group sexual intercourse with the plaintiff, Tiffany Hawkins, and other minors. C. Was in violation of encouraged and engaged in inappropriate, intimate sexual contact with a minor. C. Was in violation of criminal statutes of the state of Illinois in engaging in sexual intercourse with a minor. D. Encouraged and engaged in conduct which defendant, Robert Kelly, knew or should have known was likely to cause severe emotional harm to plaintiff, Tiffany Hawkins. Kelly contends that, because the duty to defend is broad and requires the insurer to provide a defense if there is any allegation potentially giving rise to coverage under the policy, Conway v. Country Casualty Insurance Company, 92 L2D 388, 393, 65 Il December. 934 for 42 N.E.2D 245, 247, 1982. The general allegation of conduct found in subparagraph D of the underlying complaint requires the insurance company to defend, as the allegation does not specifically refer to inappropriate sexual conduct with a minor. In our view, the underlying complaint sets forth factual allegations of sexual misconduct with a minor. Subparagraph D, read in context with the remaining allegations of the complaint, refers to the improper sexual conduct including intercourse that Kelly allegedly engaged in from 1991 until October 1994. Subparagraph D, if taken alone, is a legal conclusion, rather than a factual allegation, which does not give rise to coverage under the duty to defend. C. Alt v. CC Services Incorporated, 232 ILAP.3D 269, 273, 173 Il December. 746, 597 N.E.2D 720, 723, 1992. Legal conclusions unsupported by allegations of specific facts are insufficient to state a cause of action. Furthermore, when comparing the factual allegations of the underlying complaint to the relevant provisions of the insurance policy, a court is to ascertain and give effect to the intentions of the parties as expressed in their agreement. Crum and Forster Managers Corporation v. Resolution Trust, 156 IL. 2D 384, 391, 189 Il December. 756, 620 N.E.2D 1073, 1078, 1993. If the terms of the policy are clear and unambiguous, they must be given their plain and ordinary meaning. Outboard Marine, 154 L2D at 108, 180 Il December. 691, 607 N.E.2D at 1212. In doing so, a court is to construe the policy as a whole and take into account the type of insurance policy purchased, the nature of the risks involved, and the overall purpose of the contract. Columns 177 L2D at 479, 227 Il December. 149, 687 N.E.2D at 75. The homeowner's insurance policy in question excludes coverage for bodily injury caused by an occurrence, as defined therein, which is expected or intended by the insured. This language is clear and unambiguous, therefore, in our view, the parties did not intend to include in the definition of occurrence inappropriate sexual misconduct of a minor. Indeed, the average person purchasing homeowners insurance would cringe at the very suggestion that the person was paying for such coverage. And certainly, the person would not want to share the type of risk with other homeowners policyholders. Waters, 268 ILAP.3D at 501, 205 Il December. 936, 644 N.E.2D at 500, quoting Paro v. Main Bonding and Casualty Company, 568 A.2D 1100, 1102, Me 1990. While Kelly adamantly denies the allegations set forth in the underlying complaint, in cases where adults have been charged with having sex with minors or sexually assaulting adults, specific intent to harm is inferred as a matter of law and insurance coverage is excluded under the homeowner's policy. See Waters, 268 ILAP.3D at 507, 205 Il December. 936, 644 N.E.2D at 496 to 97, Scudder, 201 ILAP.3D at 928, 147 Il December. 386, 559 N.E.2D at 563, Bobo, 268 ILAP.3D at 516, 205 Il December. 930, 644 N.E.2D at 491. Accordingly, we agree that the insurance company is absolved from the duty to defend under Kelly's homeowner's insurance policy, as coverage is excluded under the expected or intended exclusion found therein. As such, we reverse the decision of the lower court. Because of our ruling, it is unnecessary to address the insurance company's remaining contention regarding other policy provisions it asserts were not ruled on by the lower court.
You see how R. Kelly was trying to use his insurance to cover that? Because the incidents happened in his home, so he figured he would be covered. Is that crazy? Or what? It is ridiculous. I'm going to continue to play a little bit more of Jim DeRogatis' Soulless. Let's continue to take a listen.
Several students told us other teachers there warned them the star frequently returned to cruise young girls. Abden reached out to McLean when I told him I didn't have the stomach to pose the questions that needed to be asked of the then 70-year-old gospel legend. Robert comes back all the time. He considers me his mother and mentor, McLean told Abden in a scolding tone. I don't know what he did outside of school, but in the school there was no hanky-panky. If they were involved in that, the sad thing is, it takes two to tango. She admitted she disliked Kelly's raunchier songs, but she lauded his potential. He has a very decent moral spirit inside that's dying to come out. It comes out in I Believe I Can Fly. It comes out in the Angel song he did with Celine Dion. It will eventually grow. It may be a little baby now, but it will eventually get real big. As Abden and I learned more about Tiffany, the question of what really happened with Aaliyah loomed. Tiffany's lawsuit included the marriage certificate that had been published in Vibe, as well as a 4-page petition filed by an attorney for Aaliyah in Cook County Circuit Court in July 1997, seeking, with legalistic overkill, to expunge, obliterate, erase, and/or otherwise wholly strike from all public records all marriage documents associated with the plaintiff's August 31, 1994 marriage. Abden checked, and the marriage certificate was indeed no longer available in the public records. The petition noted that the marriage had been declared invalid by the Circuit Court of Wayne County, Michigan, but Abden found that through an order by that court in October 1994, any annulment or divorce in Michigan had also been expunged, obliterated, erased, etc. We thought we'd hit another dead end until a source provided a copy of a document signed by Kelly, Aaliyah, and her parents, Michael and Diane Houghton, on September 29, 1994, less than a month after the marriage between the then 27-year-old producer and his 15-year-old protege. The agreement stipulated that in consideration of payment of $100 by Kelly to Aaliyah, two sources later told me the amount Kelly actually paid off the books was $3 million. The two would sever all personal and professional contact and pledge to avoid any public comment about their relationship or the separation agreement. Quote, due to the nature of the music industry and its ability to engender rumors and disseminate personal information, both true and untrue. In the agreement, Kelly admitted no liability or wrongdoing, and Aaliyah and her parents discharged him from any future legal claims due to, quote, a decline in her ability, reputation, or marketability, emotional distress caused by any aspect of her business or personal relationship with Robert, or physical injury or emotional pain and suffering from any assault or battery perpetrated by Robert against her person. Hankerson and an attorney for Kelly, Arnold E. Reed, were named as monitors to assure the two complied with the terms of the agreement. When Abden and I reviewed these pages with Don Hayner, the law school grad turned city editor, he thought the assault and battery clause could be boilerplate for any divorce agreement. We did not note it in our story. Only years later did the possible significance strike me, after other women began telling me Kelly allegedly physically assaulted them if they broke his rules. Unlike many who worked with him, Aaliyah's career thrived after she split with Kelly. She left Jive, the label founded by Clive Calder, and signed with Virgin Records. In 1994, Hankerson and the Houghtons came to Calder's office. Jeff Edgers of the Washington Post reported a quarter century later. There was no talk of reprimanding Kelly. Instead, the family demanded that Jive let Aaliyah go. And they basically tell me they want a release from the contract, Calder said, saying they thought Aaliyah would never get the proper promotion if she was on the same label as Kelly. Calder agreed to let her leave, but only after securing a percentage of her future album sales on a new label. Aaliyah released her second album, One in a Million, on Virgin in August 1996. A radical departure from the slick R&B sounds Kelly crafted for her debut. Many of her new, percolating grooves were written and produced by then-rising hip-hop talents Missy Elliott and Timbaland. With them, Aaliyah, quote, helped invent a style that might be called avant-garde R&B, Khalifa Sena wrote in the New York Times. While in Spin, John Caramanica contended these sounds were the nexus of street-savvy R&B and elegant pop. The collaboration between Kelly and Aaliyah became history. Whenever R. Kelly comes up, a Virgin executive told me, she doesn't even speak his name. When she came over to this label, we were all told on the sly, don't ever bring up R. Kelly's name. It's just one of those weird topics. One in a Million eventually sold more than 3 million copies in the United States, and Aaliyah also started a film career. In March 2000, she co-starred in Romeo Must Die, a streetwise retelling of Shakespeare's tragic love story. She played the daughter of a gangster in love with kung fu master Jet Li, an ex-cop investigating the murder of his brother, a member of the Chinese mob. The affair was, of course, star-crossed. Everyone I interviewed said the affection between Kelly and Aaliyah had been genuine. He loved Aaliyah, Demetrius Smith said, while he and others described her feelings for Kelly as a teenage crush turned to infatuation. Young, naive, and sheltered by her family, Aaliyah experienced independence for the first time while working on Age Ain't Nothing But a Number. All but one of my sources said she and Kelly began having sexual contact during her first recording sessions. Some said he surprised her with the marriage ceremony in a third-floor room at the Sheraton Gateway Suites in suburban Rosemont, and that Aaliyah looked nervous and scared. She thought it was all an elaborate game, one source said. Another claimed she knew she'd regret it. Her family wasn't there, but she just got swept up in the excitement. Demetrius Smith gave me the most detailed account, later repeated in his book, The Man Behind the Man. After a gig in Orlando, while on tour with Salt and Pepper, Kelly told Smith they had to return to Chicago immediately before the next show in Miami because Aaliyah had run away from home and needed to see him. When they got back to Chicago, Aaliyah told Kelly she was pregnant. Kelly's accountant, Daryl McDavid, and attorney, Gerald Margolis, convinced him he should marry his protege, Smith claimed. Neither of them would comment. Smith, Kelly, and Aaliyah obtained the Cook County marriage certificate at City Hall in suburban Maywood, using fake IDs Smith bought for Aaliyah in what he called Jewtown, slang for Chicago's famous Maxwell Street Market, which started as a Jewish ghetto but became a hotbed of electric blues and a thriving bazaar, where black vendors sold everything from discount color television sets and stereos to bootleg CDs and videos. Aaliyah lied about her age, signing the marriage certificate as an 18-year-old, she admitted in the court documents Abden and I obtained. Several other sources confirmed she told Kelly she was pregnant, but the legal filings made no mention of that. After the wedding, Smith and Kelly flew back to Florida, while Aaliyah stayed at the hotel in Rosemont. But Smith said that within a day, she left and went home to Detroit, telling her parents and Uncle Barry Hankerson what had happened. Aaliyah was a baby. She knew nothing. Aaliyah was just a sweet child, man, Smith said. Others disagreed and said some members of her family knew about the relationship. What is confirmed in the legal documents is that the family immediately set about undoing the marriage and keeping it quiet so as not to damage either star's career. We never had any trouble with Aaliyah when that was done, a family member told me. It was never her trying to see him, call him, or get to him. We didn't want any money. The issue with the family was to move on and to totally undo what Robert Kelly did. We just thought, this guy is stupid. He's like a big, dumb 15-year-old himself. At that time, we didn't think about pedophilia. It was just, how dumb can you be, boy? You lucky we are the family. We embraced her and she cried and she said she never wanted to see him again. We were apprehensive and we watched her, but we never took away the freedom of the telephone or the mobility to leave the house. She just never saw him again. Smith agreed. Rob made a mistake. That's how the family looked at it. Although Hankerson stayed on as Kelly's manager, Barry just started backing up after that. He was trying to save his family and his career. Barry is a smart man, and he's a compassionate and a good man who realizes that we are all born to sin. The relationship between Kelly and Hankerson was never the same, however, and Daryl McDavid began to play a bigger role in overseeing the singer's career long before Hankerson quit in early 2000. Instead of Dan Clora's associates, in 2000, Kelly employed as his publicist Regina Daniels, the wife of the owner of the South Side's biggest record store, George's Music Room, which boasted a wall-sized mural of Kelly. Midway through our reporting, I called Daniels to ask her about Kelly and Aaliyah. She gave me a statement that exceeded what anyone in the Kelly camp had been authorized to say, and sources told me her employers later chided her for it. Rob did date Aaliyah, yes he did, and he did have a relationship with Aaliyah, yes he did, and past that, unfortunately, it didn't work out, and that was really that. Did they have a relationship? Yes, they did. I'm not going to sit here and bullshit you or nobody else about it. Yes, they did. Did they get married? Well, there was a marriage certificate, so that pretty much kind of means something happened there. Was I there? No, I wasn't. But there was a relationship. It ended with, maybe we're over our heads, maybe this is too much, maybe we need to go our separate ways. I love you, I always will, I wish you the best, and maybe we just jumped in way too deep into this thing, and she went her way and he went his. Daniels chastised me for even asking about the relationship. Robert has done enough else in his career that if people can't say nothing else other than whether or not he screwed Aaliyah, then they can kiss my ass. Her tone made it clear she meant me. According to Smith, the sudden end of Kelly's relationship with Aaliyah crushed him. The singer finished his tour, returned to Chicago, and checked into the Hotel Nico, where he spent more than a month sleeping in the closet. Whenever Kelly got depressed, Smith said, he tried to get his friend to sing Hard Times, the song he'd written as a teen about his mom in the early days. When Kelly finally emerged, he wrote a new song called Trade in My Life that eventually appeared on the R. Kelly album in November 1995, with backing from a gospel choir led by Kirk Franklin. We both know that we made a vow, said we'd always be together, that our love would endure, yes, but now you're gone and I'm all alone, Kelly croons. The song ends with him posing the same question the heavenly voice asked a few years later in the I Wish video. What does it profit a man to gain the world and lose his soul? As Abdon
And I'm going to leave it there. That was deep. That was very, very deep. You know, poor Aaliyah. She went through so much. And her parents were not there. They weren't there. Her mother was starstruck too. The father was probably busy doing other things, working and doing what he had to do. So he probably had barely any knowledge of what was going on with her. It was all the mom, I'm pretty sure. This is all just my opinion. A lot of people failed these girls. A lot of people are responsible. Nobody cared. The community, the police, the parents, R. Kelly, the people that were in his camp, the record company. Nobody cared about these girls. They felt like they were just doing what they had to do to survive. And they were gaslighted and manipulated to thinking that they were in love. And that R. Kelly was in love with the girls too. He wasn't in love with none of them. It was all about sex and satisfying his own needs. He made sure he pleased everyone so everyone can please him back. And if you didn't want to please him, he would scold you, take your money away, punish you, not talk to you, fire you if you were against him or anything he had to say or want to do or plans, ideas. A lot of people did what they had to do because they needed money. These people worked for him. Money is a very evil thing. Money makes the world go round. Without money, you ain't got shit. A lot of these girls went through a lot of pain, suffering. And R. Kelly is where he needs to be. And his sentencing is coming up for his New York trial. He was convicted on 9 counts. He might get life in prison, minimum of 25 years to life in prison. And then he has his other court case, his next trial in Chicago, the federal case for conspiracy to defraud the government. In other words, obstruction of justice, as well as child pornography and sexual exploitation of minors. And he has to pay restitution for the Eastern District of Illinois. They had a forfeiture. Chicago, too. So, are you R. Kelly supporters going to continue to help this man once you find out he's guilty in the second case? And then when you find out he's guilty in the third, are you still going to support this man and think that this man is innocent? Come on now. Come on now. Use your common sense. All of these predators are going down one by one. Whether they're short, fat, rich or poor, they're all going down. It's about time. Especially people of power, people in the industries, in Congress, the higher-ups. They should all go down one by one. Women need to take a stand up one by one, side by side. Get rid of it all. Ain't no prayers in the world gonna help these people. God don't like ugly. Some of them can repent, change their lives. A lot of them won't. They will see brimstone and fire. R. Kelly was so cocky, so narcissistic, that he brought all of this on himself. There is no one else to blame but himself. He knew what he was doing. He has a sickness, an addiction, and it's criminal what he's doing. And he knows that what he's doing is criminal. That's why he has been hiding and covering up his tracks for years. They should have done this shit 30 years ago. It's too late. Nah, my man, it's not too late. Your seat in jail has been sitting there on ice waiting for you. So you can come and sit on your throne in a 6x6 cell with bars, a toilet, and a hard-ass bed where you can't sleep, where you could barely eat, told what to do, how to do it. You're gonna enjoy life in prison, R. Kelly. You are. While you're there, get the help you need. While you're there, get the help you need. You've needed help for a long time, and no one has helped you. And it's a shame. People tried, but you know what? People can't help those that don't want to help themselves. So if you don't really want to help yourself, can't nobody really help you. Maybe now you can sit and dwell on all of this. I mean, you've been there already for almost 3 years and you still haven't said to yourself, you know what? I am guilty of all this shit. I know what I did was wrong. People owe me, but I owe them. And I should make it right with God and with these victims that I've made. We all need help. And it starts with me. But you can't do that, R. Kelly, can you? You're too set in your ways. And it's a damn shame. Well, guys, I'm going to end this live. I hope you guys enjoyed it, got plenty of information from it. The information lady is doing what she should do. OCOV is keeping our foot on R. Kelly's neck. And that's it, that's all. And this case is a shame for everyone. It's sad for everyone. Guys, don't forget, for those watching the replay, leave your comments below in the comment section of the video, please. While you're at it, guys, for those that are in here, please make sure you like the video. For those who are watching for the first time, please subscribe. Hit the notification bell on the side. You can catch all my lives as they come and go. And if you would like to join my members only club, the Badass Divas, it's $1.99 a month. You get little perks. You get to put emojis in the chat. I got cute little emojis going on there. And you also get badges month to month. And I get to share private moments with you and exclusive things and all that good stuff. And once again, guys, thanks for joining the show. Thank you for all your support. Make sure you guys hit that like button. Share the show. Share. Let's see me grow, guys. Hook a sister up and share. And just remember, this woman has zero tolerance for violence against women, as well as everyone in this chat. OCOV, I love y'all. And if you would like to donate to our brother Larry, please do so. Cash App is $Cuphead40. And you guys know, if you would like to donate to me as well, my Cash App is Diva Divine Light. It's underneath my avatar. Y'all know what it is. And Diva Divine Light is out. Peace.
Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
With no delaying for what you saying, yo. Silly with my 9 million with the dilly, yo. When I be on my guess I do my duty, yo. While up in the club, like we while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug nigga named Julio, he moody, yo. I'm a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fuck me, see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
hard-hearted to me. Let me see just what you got for me. Put more than years with my eyes to see. $2 in a place to be. If you really hard-hearted with me, let me see just what you got for me. Put more than years with my eyes to see. $2 in a place to be. If you really hard-hearted with me, let me see just what you got for me. Put more than years with my eyes to see. $2 in a place to be. If you really hard-hearted with me, let me see just what you got for me. Put more than years with my eyes to see. $2 in a place to be. If you
Here comes the pitch, and it comes in wide. On the count ball.